suffer.
Maybe they can because it's all equipment. No, I know.
You're in dire need of revolving doors. It's like we've had the technology for a while. Okay, so
To get out after like 5:15.
so a live stream. I don't want to go to
Yeah.
But it's some of those kind of special police. The church badge, it's what they carry a weapon, no question. Live stream. I don't know what I want to go with there, but I'm telling you, they frankly make me laugh. You're on. The call, that's question.
The time is 11:37. It is December 4th, 2014. We are the Board of Ethics and Government Accountability, and we are here for our monthly meeting at 1 Judiciary Square, Suite 540 South. I think it would be appropriate today. We have a quorum. Ms. Lathan, Ms. Richards, and myself are all here. It's the full complement of the board. I think it would be appropriate to start the meeting out today with a moment of silence to remember our former mayor and council member, Marion Barry, who passed away last weekend. His body's lying in state today at the Wilson Building, and there'll be a number of different events memorializing his service to the District of Columbia. So I would ask everyone for a moment of silence. Okay, thank you very much. We have an agenda that was posted consistent with the Open Meetings Act. Are there any amendments or changes to the agenda, Ms. Richards?
I have none.
Ms. Lathan? All right, so by consensus, we'll adopt the agenda. We do have a quorum, as we said in the very beginning, which means we can turn to our item 4, which is a report by the Director of Open Government.
Thank you. I'm going to try to get through this without losing my voice. Last night, we held our second meeting of the Mayor's Open Government Advisory Group. The group has reviewed the open government reports submitted by agencies and has taken a tally of public bodies that have web streaming capability. The group will issue a report regarding current compliance with the Open Government and Transparency Directive issued by Mayor Gray, and the goal is to submit that report to Mayor Gray before the end of his term, so coming up pretty shortly.
Okay.
By the way, for the tally for the public bodies who have the ability to currently webcast, we are now included in that list. We're testing out our webcasting capability as we speak. I'm working with Octo to make sure that we can live chat. So we're going to be testing it out with Eric upstairs, and if you see me typing, it's probably because I'm answering Eric's questions just to see if it works.
Okay.
But so far, so good. So hopefully by the next meeting we'll be fully operational and it will work well and we can start advertising it.
Terrific. Thank you for your efforts with this.
Sure.
And I know that there are many technical hurdles that have to be overcome and some relationships that need to be built in order to make this happen. Right. So we appreciate your effort.
So there are, just in case the board is interested, there are currently now 10 public bodies that have the ability to webcast. I have asked Rob Mancini at Octo, per the advisory group, to provide a list of those spaces in and around the city that have the ability to webcast, particularly for those public bodies who may want to hold their meetings in those locations. So we have that list as well, and it looks like there are about, just at a quick glance, about 10 or 15 of those, including the Executive Office of the Mayor. But we're going to be working through all the challenges surrounding the webcasting and how we get it done and infrastructure and the like. Also, during the meeting last night, and to ensure continuity with the new administration, I was nominated by the chair of our advisory group, Brian Flowers, to be the vice chair of the advisory group.
Oh, great.
So
That's
pursuant to the
good.
bylaws, the chair of the advisory group has the ability to designate a vice chair, and the group agreed unanimously. So I will be chairing until further notice, and until the mayor-elect says that she wants the group to continue or not.
That's great. I mean, I do think also that reflects a terrific shift in positive shift forward in the relationship between the executive office of the mayor and the board.
Yes.
By recognizing your importance in the Open Government and Open Data Initiative, because I know that there was some question about what your role would be in the very beginning, and to have you as vice chair of the advisory group, I think is outstanding.
It's like moving mountains, but we've done it. So far, so good.
One spoonful at a time.
Right. On next Monday, Mayor-elect Bowser's transition team is going to hold a public forum on open government and full democracy. That's to start at 10 a.m. in the Board of Zoning in 220 South. Darrin and I will attend, and I have signed up to speak, but they've done it through Google, and just anyone and everyone can sign up if they choose to. So I'm sure that I'll be part of a long list, but hopefully I'll have the opportunity to address that forum. On November 13th, I participated in a very productive discussion among leaders from nonprofits, NGOs, and universities and government officials at the Urban Institute, and that was the date of the last board meeting. There were several ideas that were offered that would improve government transparency and foster partnerships between government and the private sectors to improve district services and agency operations. I think the Urban Institute is planning to submit its own action plan to the incoming mayor. I don't know how soon they plan to do that, but that was the purpose of the discussion. I also participated in a November 20th panel discussion offered by the World Bank called Beyond Hacking for Good, an Inclusive Government and Citizen, a Friendly Approach Towards Civic Tech. That panel was convened by Sandra Moscoso of the World Bank, who is a data enthusiast and just in her private time is all over the open data world. The panelists included Chao Lang Ko. He's a Taiwanese software developer who founded a civic tech organization in Taiwan that advocates for information transparency, tools for improving citizen participation, Laura McCann of the Open Tech Institute with the New America Foundation, and Stephen Davenport, who is a senior governance specialist of digital engagement at the World Bank. I'd just like to mention that I think that there's ample opportunity here, particularly with the World Bank, because it has a very robust digital engagement division, if that's the best term for it, for the city to partner with the World Bank, because they've got many tools in place already that will address many of the ideas that have been raised over the past year. So rather than reinvent the wheel, I'd like for this body to consider perhaps taking a closer look at the offerings of the World Bank and forming a more solid partnership with that organization.
That sounds very interesting. I know that the World Bank has to work closely with the district government because of a lot of the activities that occur there, and so they're very engaged with, MPD and DDOT and other agencies. So they've got I know they have existing relationships with the DC government. I think building one with us sounds great. Yeah,
Stephen Davenport asked, how do we partner with the government? And I think there's just this natural disconnect because they don't know who to talk to. Sure. So I'm going to see if I can set up a meeting with him to find out what the offerings are and maybe something that we can or can't do. But I'll definitely look into it.
Sure.
For trainings, I conducted a FOIA training of DC Public School FOIA personnel on November 21st and an Open Meetings Act training of the DC Office of Veterans Affairs Board on November 13th. Finally, the IT position, I've completed the interview process, and I hope that the chosen candidate will be on board by December 15th. It's my understanding that the board members, we got our times confused today, so he was to arrive prior to the meeting, but I believe it's been conveyed that Deborah and Laura, you've agreed to meet with him at 1:30 today?
That is correct.
Okay, and then Bob, if you're available.
Sure.
Last but not least, and this may take up the bulk of our discussion concerning the Open Government Office update, is the rulemaking. The comment period for the proposed rulemaking for processing complaints and training has closed. Only one comment was received, and it was submitted by representatives of the Open Government Coalition on November 24th. Considering the timing of the submission of the comment period is right before the holiday, I didn't have the opportunity to pull back the proposed rulemaking, nor do I think that's a necessity, but I just wanted to make that clear that we received the comments pretty late in the process. But generally, the comments are provided in your briefing materials, but I'll just provide to you just a brief description of what they would like to see happen. So they want to remove the willful disregard standard They believe that it imposes a necessarily high bar prior to the Office of Open Government bringing an enforcement action in D.C. Superior Court. And it goes beyond what is required by the Open Meetings Act, namely that there are no restrictions in place on when the Office of Open Government may file suit. Removal of Section 10403.1 because they believe that language will encourage an investigation into the complainant rather than the public body. That particular section just simply says that the Office of Open Government may consider, among other things, the complaint itself if another complaint has been lodged by that complainant before. And I think that the Open Government Coalition assumed that that language would require perhaps some review of the person lodging the complaint rather than taking in the totality of the circumstances regarding the complaint, which is what I explained to them. To modify Section 10400.1, to remove that, they want to remove that language that may place restrictions on who may file a complaint. And that section just simply says anyone who believes that they have not received notice of a meeting may file a complaint. I'm not entirely sure why they think that would limit the individuals who may, or restrict the individuals who could submit a complaint to the office. Section 10406.1, they would like to remove the binding effect of advisory opinions, which I do not agree with at all, because if the Office of Open Government has been required to issue an advisory opinion, been asked to issue an advisory opinion, it should be maintained.
That's a weird one. Why did they want to not do it, or what did they see as the danger of making an advisory committee opinion mandatory?
That's a very good question.
Yeah, let's see.
Is it a precedential value question? I mean, are they worried that it will be, in a particular case, be transported over to another case that, right? I mean, I don't.
Here it says, advisory opinions by their very nature are intended to advise and provide information rather than to bind and impose legal imperatives, which is contrary to the way this body operates on the ethics side.
Absolutely.
Which is why I inserted the language making the advisory opinions binding.
Right.
It says, while the Act contemplates that the OOG will issue advisory opinions to provide information and guidance to the public and public bodies, it does not provide that advisory opinions are binding. Among other reasons, we are concerned that this statement might discourage public bodies from coming forward with questions regarding interpretation of the Act.
Okay, so this, again, we get so many, on the ethics side, so many informal requests for advice and guidance, and I'm sure you do on a regular basis as well. That does not mean that in an appropriate case, a binding advisory opinion that actually protects the government employee once a decision is made doesn't make sense. I mean, I agree with Ms. Richardson. I can't understand. It would be meaningless to issue an opinion that then the agency could say, you know what, thanks for your view, but we're not following it. And it would, once it started, it would render ineffective something that should be very effective under the circumstances. So it seems like we've got an agreement on that.
Okay.
If that's their concern, I mean, I just rename it as an interpretive opinion, which would be quite clear then that it's intended to be a binding interpretation of the statute. If their concern is for maintaining the integrity of the word advisory.
Okay.
But go ahead.
Okay. And then revise section 10404.2 to allow for a public record of conciliated complaints. So the concern here is that the rulemaking as written says that the director will not issue an advisory opinion on a complaint resolved through conciliation. And when we discussed the rulemaking initially, we all agreed that we need some type of intermediary step. So their concern is that there will be no public record of that conciliation, that a complaint was filed, that the rulemaking doesn't specifically say that there will be a record of the conciliation and the complaint filed and posted online. So I don't have a problem with that necessarily, because that certainly wasn't the intention of the rulemaking, that we would not make that information public. Right. But that is one of the areas that they would like for this body to consider revising.
So the idea would be that the existence of the complaint would be public, and then just some notation that it has been conciliated or negotiated out and resolved without any long discussion about well, they said this, and we said this, and they said this, and we said that, and then eventually it got resolved. Is that the idea?
That's the idea.
Okay.
Now, for the advisory opinion too, because there's language in the rulemaking that says that with the consent of the agency or party requesting the advisory opinion, we would post that opinion with certain redactions.
Right.
Again, that to be consistent with the ethics side of the House. They believe that all advisory opinions should be posted without redaction, unless except under very limited circumstances. Now, there's maybe some merit to that one there because we're talking about open government, and
right, but it could also contain information that would otherwise be because it would be confidential or covered by various privacy requirements,
right?
HIPAA.
Right.
Privacy Act, take your pick. So I think that the ability, well, it certainly wouldn't be, we're not redacting everything out of it, but I certainly think anything that would be otherwise protected by law should be redacted.
I agree. I agree. I think we've got to review them on a case-by-case basis.
Right, I agree.
Now, for the willful disregard language, I'd like to go back to the first one for just a moment. We had initially discussed that when we reviewed the draft rulemaking, that we needed to have some parameters or some bar for what is going to allow this office to file a suit, and not necessarily for our direction, but more so for the public to know that we're not just going to be going out and
right. If you
filing actions in DC Superior Court.
If you're 1 day late with a response, people should not be expecting us to be marching in to Superior Court filing actions. So did they recommend what the standard should be? Willful disregard seems right to me, but I'd be open to hearing what else.
If they're interpreting willful as old-fashioned intentional, then we might be able to resolve that by saying willful or reckless.
They, in fact, recommend cutting that entire section entirely because they think that it places
no standard.
Yes, they think that it places restrictions on the office to file action in DC Superior Court. Period. I don't agree with that. I think that there needs to be some parameters set.
Go ahead.
And what would be your thought as to the parameters? I mean, there's got to be something between willful disregard and nothing.
Well, I think it should be willful disregard. I mean, maybe like an intermediary would be, arbitrary and capricious. I know that's too lame.
But I actually like Ms. Richards' suggestion of willful or reckless.
Reckless.
Because that's obviously a higher standard than simple negligence.
Yes.
And it does sort of encompass the intentional, willful part, but also any reasonable person would have done it, and the fact that even if you didn't intend to do whatever it is you did or did not do, you were reckless in the nature. And that's a standard that's got plenty of law behind it. Mm-hmm. It's got plenty of interpretation behind it in other parts of the law. So I kind of like that one.
And I think another reason that it works is because we're still very much in the infancy stage with the application of the Open Meetings Act. And I don't want public bodies to feel paranoid, particularly if they don't have the tools in place, they couldn't comply for whatever reason. Right. There has to be a very high bar. I think we have to check a few boxes before we go after public bodies in any kind of enforcement action.
No, I agree.
Okay.
I totally agree. Are you okay with reckless? Willful or reckless disregard? So
what that will require, I'll have to do another proposed rulemaking, and we go through another comment period?
No, I think you can do that I think that falls under the category of change that does not require notice and comment.
Okay. I don't know.
It's a relatively minor change to the overall scheme. It's not like we took out a whole enforcement proceeding or we added something in there. I agree with Ms. Richards. I think it's a fairly modest change that does not require yet another round of comment.
Let me suggest you just check with ODE to get there, because they have an other opinion about whether another publication is necessary.
Okay.
We'll find out about it start of the process.
I'll check with her today. Okay.
The other one, were you planning to revisit the comment about our provision of the rule invites investigation of the complainant rather than the agency's action?
No, because if you take a look at the language itself of the rulemaking, let's see. That section is 104.03.1, and the specific language is this. In making findings and determinations under this chapter, the director or designee shall consider the alleged violation and including but not limited to the following factors: the nature, content, language, or subject matter of the complaint, the nature, content, language, or subject matter of prior or contemporaneous complaints by the person making the complaint, and the nature, content, language, or subject matter of other verbal and written communications to any public body or any official of a public body from the person making the complaint. So it says, I'm hanging my hat on including but not limited to, and it was my effort to give us some flexibility to take into consideration the full context of why a complaint is being lodged and what occurred at the meeting or didn't occur.
So, and I know that the goal of that was to I guess, protect agencies from sort of serial filers without a real reason to act. And I suppose that the commenter is saying, look, some good government group may put a lot of time and trouble into monitoring these things, and they may indeed, find things that need to be corrected and make multiple filings, etc. And that's a good thing. There might be some softening or language or some minor edits you could make that, also I'm going to say wouldn't require, further comment period, subject to the second opinion. But if you can do a bit of editing without requiring comment, you might try tweaking it a bit.
I mean, this is a non-exclusive list, so it strikes me that it's the same whether it's in or out, right?
Yes.
This doesn't prevent you from considering that factor. The only question is whether it's explicit in the list, right?
That's
but
right.
It's not exclusive.
That's right.
As you point out.
That's right.
So, I mean,
they're just. We were trying to not make the agencies feel they were going to be at risk, and instead the good government groups are saying, hey, look.
And quite frankly, these things would have to be considered anyway, if you're doing your due diligence and investigating a complaint.
Sure, sure.
Absolutely.
All these factors would be factors in that consideration. So the fact that they're listed or not, I don't know that ultimately it changes the process.
I mean, if there was some and I wouldn't take out the whole list. If there was some kind of gentling language, fine. But I mean, I wouldn't. If you can't think of anything or don't think it's worthwhile, I don't feel strongly.
Yeah, and I'm comfortable with the way it is. Again, I agree. If there is some adjective or adverb or something you could throw in there to soften it a little bit, I'd be fine with that. But because it's a non-exclusive list, whether it's in or out, strikes me as being the same in terms of the actual work that gets done. But I think that, as Ms. Richard points out, having it at least identified in the rule will give the agency some comfort that not everything is going to result in an action, that you will consider all the things, including the serial filers. And we've had this experience, obviously, on the ethics side.
Right.
So,
Ms. Lathan, do you? Okay. Do you all want additional time to consider the comment by the Open Government Coalition, or are you okay with me proceeding?
I'm okay with you proceeding.
Okay. And then finally, the Open Government Coalition did submit its action plan to Mayor-elect Bowser, I think mid-November or so. That action plan is also in your briefing materials. The recommendations call for the incoming administration's adoption of Mayor Gray's Transparency and Open Data Directive, amending the Freedom of Information Act and the Open Meetings Act, and giving the Office of Open Government greater authority to monitor and enforce those acts, and ensure the office is involved in decisions and policies concerning government transparency. So there was just as an aside, some brief discussion between Brian Flowers and myself concerning this action plan, because Robert Becker is a member of the Mayor's Open Government Advisory Group. And the plan is also being taken up and considered by the advisory group to offer some next steps to the administration. I did explain to Brian that I'm more than happy to recuse myself from any kind of formal votes or actions taken by the body as it relates to the open government's action plan and consideration by this group, because so many of the recommendations in that action plan have a direct impact on me and my office. So,
but I think it's important that you be part, even if you don't vote, and that's a decision I think you have to make for yourself, but your voice about what makes sense, what works, what doesn't work,
for
I
sure.
think is very important.
Yeah, I'll be in the room and will
Right.
offer input, but I just won't vote. So I think that's the best way to proceed.
Okay.
Okay. So that concludes my report. Are there any other questions?
Oh, I just had a couple of comments and questions on the operation of, I guess, our new FOIA Express. And, I did file my FOIA Express question, and I found that the system generated a very rapid response, but content-wise, I thought it imposed a greater burden on the requester than was necessary. And I mentioned this, not for any, action to be taken, but I'm refiling and filing, making additional filings, because now that we have this capacity, I wanted to produce more government information, not okay, file a better request. I promptly told.
I don't understand. So you're referring to when you file a request or when you submit your profile information?
I filed a FOIA request on the system, and it generated back, hey, we got your FOIA request very promptly, and we'll get back to you in a timely fashion. And I filed what I considered to be a sufficiently targeted and detailed FOIA request. And I received a response saying that you did not submit sufficient information to permit a search to be made. While I may question that, I'm refiling. And then I was directed to a public database in addition, but that public database has been reorganized and requires a new password, which the computers would not let me obtain at that time. So I'm just saying that I'm participating in the oversight of the user friendliness of how FOIA actually operates under our new system. And I will make a further request after I have submitted my reformulated, highly detailed FOIA request. But it should not, have to, I think
I agree.
Little work on the other end might have saved me this trouble. Now, I was also, I was rereading some of the comments submitted at our 2013 symposium, and I noted that one of our commenters filed very extensive reports detailing their difficulty in getting a DC school budget in adequate and readable form. And this was, they were saying, hey, it took them 6 months to get the information that they had requested, and they got the runaround. And the nature of the budget information that was publicly available wasn't meaningful for details outlined therein. And as we get into the budget season, I just wondered, that's one of the things that DC residents sometimes find hardest to parse. So I just was going to ask the Office of Open Government to kind of keep an eye on the budget information as it comes out, and see how usable the public is finding it, or see how usable you find it.
Okay, I'll certainly do that. There were on the mayor elected a conference call yesterday with district government employees, and that was one of the things that she mentioned. She wants her tech folks to take a look at simplifying the budget process, and then making sure that all the information that is submitted, the public can easily access it. So. But I'm happy to take a look. But I just raised that so that you know that it appears to be on her team's radar as well.
Well, thanks. There's a nonprofit that's kind of dedicated to helping citizens get through the budget, and I don't know if they have any thoughts about what could be done through open government.
Do you know what the name of that nonprofit?
I'm having a senior moment. I'm
Okay.
sure I'll remember before we leave.
Okay. And then if also, please, if you don't mind sending me the communications that you've received through FOIA Express.
Thanks.
And
I'll
then
do that.
I'll see what I can do.
Well, I don't want you to intervene in this. I just want you, because that would be inappropriate.
No. I'm just saying I'll see what I can do with the vendor, that perhaps there's a simple modification on the back end, or maybe it's a human error. I don't know. Sounds like it may be at the agency level, but.
But I would say I just would not and would not want to create any appearance that I was like using this podium to get any FOIA request expedited or anything.
Okay.
I'm simply reporting. Thank you.
Okay.
Okay, anything else? All right, let's move on to the report by the Director of Government Ethics, Mr. Sobin.
Good afternoon, board members. Just checking. I think we are into the afternoon at this point. Good to see everybody. It's been 3 short weeks since we last met. I'm just going to run through the list because we do have a number of things on the investigation side that need to be discussed in the confidential portion of the meeting. Investigations, we opened 3 this month. We closed 6, so we made some headway, which brings us back to our normal current operating number of 15 open investigations. There were 5 undocketed matters that were open, and we were able to close all of them right away, thank goodness. We are up to date on our publication obligations and reporting obligations. One of the things we had to do was come up with a list for a schedule for next year's meetings. That's been done, and I'm pretty sure it's been published. If it's not, it'll be published next week. Trainings, Ms. Alawamne, our investigator, attended a training on government contracts and government contracting, so we can get some more experience in the procurement area. Conducted by the staff, we conducted 3 trainings since our last board meeting. 1 was on post-employment, and 2 were new employee orientations. On the advisory opinions, we received no formal advisory opinion request this month. Currently, we have 2 advisory opinions in process, including one that's a sua sponte opinion on the Local Hatch Act. We received 39 informal advice requests this month, which we responded to in writing. Excuse me. Two of them of note I'll just mention. One involved, of course, the holiday gifts and parties. We issued one last year for the council and one for the executive. And on the executive side, things changed quite a bit with the April publishing of the new DPM. So we pulled them both back and revised them and reissued them. Of course, we always receive calls this time of year about it, so we think that these opinions, offer good guidance. They're plain English. They say what people can do with regard to gifts, what they can't do with regard to parties, when they're asked to contribute to parties, things of that nature. It's also open season, so we've got for re-upping with various insurance agencies in the district. We received a report from one of our ethics counselors in the agencies that one of the providers was well, at the time he said that they were gift cards in the amount of $25 each to anybody who would sit and speak with the carrier's representatives. And so we said, well, that's a problem. So we investigated it. We checked with DCHR, and as it turned out, it was a coupon. It wasn't a gift card. It was a discount coupon that could be used at area restaurants. And even though it had a face value of a $25 discount, it couldn't be redeemed for cash. It had to be in conjunction with a purchase, and it only cost the carrier $2.25. Nonetheless, DCHR jumped on it and quickly got the carrier to agree to reduce the value of the coupon by $10, which is the limit even for prohibited sources, which I appreciated because we were still uncertain whether they wanted to do it or whether they had to do it, but from a best practices perspective, they did it. Okay, we've been working hard on the best practices report, as you've probably seen by the emails that have gone around. Mr. Grimaldi sent the Ethics Board a draft earlier this week. He's seeking comments from the board members. We've, at the OGE, provided our comments, which were incorporated, and they're in the draft that was sent around to you. As you know, the best practices report is due by December 31st, but we'd like to get it out before then. Mr. Grimaldi?
I've got a couple of things. What I did for the board is give you a hard copy of the draft introduction. When I get back to the office, I'll send you the e-copy as well. What I'd like in terms of a timeline is maybe get your collective comments by the end of next week, which would be the 12th, either redlining the Word document or by email. That way, I would look to get a revised draft, if not fairly final draft, circulated by the end of the week after. That would be the week ending, I think, the 19th.
Right.
Okay, which would give us plenty of time, factoring in the holiday, to tweak it and get it in by
Yeah, I so I think it's doing. It's at least by my reading, it's in very good shape. So I don't expect to have many comments.
Is this different than the draft that I already read, the one that was in Dropbox?
This is the introduction. What was in the Dropbox didn't have the revised introduction.
Okay. Okay. So this is different. Okay.
Right. And I just want to note to the board that the process this year was much more streamlined, smoother, and that in large part is due to the people sitting in front of you who were very good in terms of telling me what they thought should go into it, giving me comments along the way, and it was very much a collective effort.
That's
I
great.
appreciate it.
We appreciate everyone's efforts in this. For you were not here, Mr. Grimaldi, during year one of this process. Let's just say that it was, as my mother would say, like making sausage. So, this year, not so much. But thank you very much. And we'll get you your comments no later than next week.
Okay. Item F, the Comprehensive Code of Conduct, has been on hold just a little bit because of our focus on the BPR and the deadline there. And also because we haven't gotten comments back yet from some of the folks in the government we distributed it to, namely the council, general counsel of the council, who had promised comments soon but has been preoccupied with other things. And on the executive side, with the transition going on, I think the plan right now is to share it with the folks on some of the folks working on the transition in anticipation of them taking over in January. So I think a realistic sort of time to get into the Comprehensive Code of Conduct is probably going to be at the January board meeting.
And it's safe to assume that given who was on Mayor-elect Bowser's transition team, specifically Thorne Posen, who's very familiar with this process, that they're aware that we are within a stone's throw of finishing this up.
Yep, and I've made that clear.
Sure.
On item G, I don't have anything to report on the budget. H, lobbyist financial disclosure matters. We have a couple of FDS fine waiver requests. As you recall, we sent out the fine letters where I imposed a ministerial fine and invited people who wanted to appeal that to file with the board. They've done so in two cases. In 12-62-001, Mr. Robert Sonderman, OGE imposed a $300 fine on Mr. Sonderman for his failure to file a timely FDS form. He was requesting that the fine be waived because he was thinking of resigning his board position and thought he did not have to file. Ultimately,
because he was thinking about resigning, he didn't have to file?
You have it in writing, and say, I'm not really paraphrasing it. I think that's what it actually says in there.
Okay.
Ultimately, he did not resign his position. OGE opposes waiver of the fine, even though Mr. Sonderman did finally file his FDS form on November 16th. So if you want to take that up.
I'm happy not to waive it because when we decided, at the meeting at which we decided to impose these, I think we went exhaustively afterwards, and staff has given us many, many briefings on the efforts they make. And And even after, and I think they even got final notice that, hey, you're going to get fined if you don't, because our concern had been that people didn't really realize, because it was either not told explicitly or not in the fine print, that they could face a fine. So they had a last opportunity to file before becoming subject to the fine. And if you miss it after that point, I think we even, like Mark, put something on the outside of the envelope, don't ignore this, this is a bill, could be a bill.
I also think, with all due respect to Mr. Sonderman, the basis for it has several things wrong with it, including the fact that you're filing for the previous year, of course. So whether you're thinking of resigning going forward is one thing. Thinking about resigning is not a reason not to do it. Even if he had resigned, he'd still need to file it. So I agree with Ms. Richards. I can't see a basis to waive the fine.
Ms. Lathan? Okay, the record reflect that the appeal is denied.
Which board was this?
I'm sorry?
Which board is this?
Mr. Sonderman, what board does he sit on?
Historic Preservation Review Board.
Right.
This is the same individual that said he had been on the board for 22 years and had never requested his stipend be paid either. And so he calculated that he would have made, I forgot, but quite a bit of money if he had accepted his stipend. And so he seems to be arguing that in lieu of his stipend, because he didn't take his stipend, that we shouldn't be fining him. I think you might just want to simply, in a very simple way, address that by saying, that, of course, the district appreciates his services in the Historical Preservation Society for 22 years, but essentially there's no quid pro quo. He would have to pay his parking tickets if he,
volunteered for DPW.
Exactly. So,
I gotcha.
I didn't quite get the rationale of I didn't take my stipend, so I shouldn't have to be fined.
Okay.
So, but I think you might just want to.
The district said a net gain, I guess, is his point.
That's his point, exactly. But I think you have to have a sentence or two in there thanking him for the 22 years, but this is not the way it works.
Well, since has the order been signed?
Well, you put it in an email.
Okay, we'll put it on the cover. Okay. All right. The other one is 1263-001, Bernadette Tolson. OG imposed a $300 fine on Ms. Tolson for her failure to file a timely FDS form. She requests that the fine be waived because she had health issues in the early part of 2014, resulting in her having surgery in October 2014. We are opposing the waiver of the fine, and note that to date, she still hasn't filed her FDS form.
Has she been at work during this time period? Do you know, Christine?
She left the board in July, and she didn't have the medical, according to the email, she left the board in July and didn't have any of the medical procedures until after that point.
Okay.
And at that point, we had sent out at least the reminder letter and, depending on what time she left in July, the notice of non-compliance.
Which board is this?
This is the DC Housing Authority. There was also an indication that, given that for filing for May 15th of 2013, we had given the DC Housing Authority Board an extension for last year, essentially, because we were working out that they were required to file or not, and she was under the impression, this was verbally, that there was another extension to file. All the other members of the DC Housing Authority Board filed by October 29th.
Okay, she said she had complete knee replacement on October 7th, 2014 at Hopkins, and then there were complications that followed that, and that basically her focus essentially was on her knees and not on this. And she's she's a 71-year-old senior, and she's going to see if she can get her daughter to help her file online. Okay.
And your views are?
Well, I guess I'm trying to understand. Walk me through the timeline on when she should have filed.
So we send out the reminder letters. Hers would have gone out either April 17th or April 29th. Those are the reminder letters you are required to file. Here's your password, here's your username, and if you want to file hard copy, here's where the form is located.
So this is prior to her surgery. She gets this in April, and her surgery's in October.
Yep, this is end of April 2014. May 15th, 2014 is when the filing deadline. Then we go to June 15th, which was our reporting deadline to the register. We contacted some people's offices at that point, and I contacted the head of the DC Housing Authority Board, Mr. Alfonso, letting him know that there were still people who needed to file. Then in July, at the end of July, July 30th, we sent out a notice of noncompliance. Then I believe in August, we sent out a second notice of noncompliance for the people who still had yet to comply. Then at the very beginning of October, after discussing it with the board, we sent out the third notice of noncompliance that notified them of the possibility of a fine. Then at the end of October, we sent out the letter that said, you have been fined because you did not file by October.
And had she filed in the past?
She did file last year, yes. But there, like I said, the circumstances with the Housing Authority Board were slightly different last year in the sense that they had an extension to file beyond the May 15th deadline last year.
No, I'm okay with them with not waiving it. I mean, there were ample opportunities to get it done.
I can go with not waiving this, but I will say that I'm influenced, this one and the other one, by the fact that these are core government functions and that are being overseen here. And I might have a slightly different view if we were talking about a strictly advisory meets twice a year board. But I think this request points up what we have discussed and what staff, and I think is a gender gap, an age gap here is sort of insensitive to. A lot of older people, even people who are like savvy enough to serve on boards and handle complex issues, just aren't that comfortable sitting down to, file things online. You think some are, some aren't, and some of them don't live and die by the email, and if we're going to insist on requiring electronic filing, which is the way the world is going, we have to really impress upon the agencies served by these, that are subject to the oversight of these boards and commissions, that they have to help police it along. There's I mentioned the case of an individual who was on a board and didn't know, and so I think the directors of these agencies have to play a stronger role in educating the boards and commission members.
I think that's an excellent point, and particularly this lady's 71 years old, and I certainly know a lot of people in that age group that don't know the first thing about even using a computer, and they don't have smartphones, and so perhaps there should be some assistance, not provided by us because we're definitely overloaded, but by the agencies, and for people like her to say, look, if you don't know how to file online, there's someone here in IT, but someone here can assist you.
Oh, we're happy to walk them through it. Absolutely. Christina does that a bit, quite a bit.
We're just telling them, the agencies need to be telling them, you really got to file, board member. You don't need to give us a copy, but they're really serious. This is part of your board service.
I think what we're going to try to do next year, and this is, what you're saying is exactly what we discovered in October, after we sent the first letter indicating that there was a fine, after the board had expressed that we really wanted to ensure that everyone had ample notice that there would be a fine, I contacted the heads of each agency, board, or commission that still had remaining non-filers to say, there are people at your agency who still have not filed and will be fined $300. Here is that list of people. And I think that our hope is that next year, after the May 15th deadline, but before our publishing deadline, we'll be able to do the same thing. So we can say hi to the head of the DC Housing Authority, to the Historic Preservation Review Board and the Office of Planning. Here are the people at your agency who have not yet filed. Contact these people and figure out why they haven't filed. So it puts the onus on them to ensure that their employees or commission members or board members have filed.
Great, thanks.
The reaction to that was great.
Good.
People really wanted to, the people who we got in contact with really responded to us and wanted to get their people filed, and it was very good.
Yeah, I guess I find myself in the same camp. I'm not, she had surgery and she's 71. But on the other hand, there's been plenty of notice. And the thing that I'm very persuaded by Ms. Richards' point about the core function of the board and the fact she's been a long-serving member, but also the fact that it's still not filed. That's the problem, is that it's still not filed. The staff goes through such great lengths, and we could be slapping fines way early in this whole process, but we don't. And we defer because the goal is we want people to file. We don't want to be a gotcha agency. And so I think that we were more than patient with Ms. Tolson, and so I would agree. So I think
I have one question, because this raises access issues with regard to the access to technology and the ability to not only just file online, but you have access to a computer to do so. So in our communications, do we include some mention perhaps on the second or third warning if you don't have the ability to use a computer or you don't have access to a computer, you can come into the BEGA office?
well, of course they can
From the very beginning, from the very first reminder letter, there's a paragraph about electronic filing and a paragraph about hard copy filing. And there's an indication both in our training screens and I think in our FAQs that people can come in, call us, and pick up forms from our office. In fact, Eric keeps a folder of blank FDS forms at his desk that people just come in and pick up.
And apparently she was still on the board at the time the filing was required, so she would have had access through them too.
Okay.
So, for the record, the appeal is denied.
It is unanimously.
Okay. So those are the appeals, and so in the absence of any other appeals, we sent out demand letters on December 1st, and we anticipate that we'll be referring to OAG all of those that don't respond to the demand letter at the end of this month. We've already spoken to them. They're willing to do it. We'll just package them up and off they'll go.
These are demand letters.
For the $300 fine.
Oh, gotcha.
For the other what was it, seven?
There were 15. We sent
15 demand letters.
Okay.
Which is not bad considering we started out with over 900 folks who had to file. All right, new legislation, item I. You might have seen I sent around that article about the District Government Certificate of Good Standing Filing Requirement Amendment Act of 2014. On November 19th, I testified before the council on this legislation. In my testimony, I pointed out that the problem with the DOES administrative law judge, which, as I understand it, is the issue that led to the drafting of the bill, would not be addressed by the bill as drafted. In addition, I pointed out that the submission date of May 15th was not as good as a date as December 15th, given that the DC bar registrations are due by July 1, and there needs to be time for the bar to process and them to be completed. Finally, I pointed out in my testimony that even though the bill requires BEGA to be the repository of the bar certifications, DCHR still has the enforcement authority as well as the authority to require agencies to provide it with the names of those who need to file certifications. Nonetheless, on December 2nd, the bill passed, first reading, although the filing date was changed from May 15th to December 15th, and conceivably it would take effect next year for the next December filing season. It's essentially, it's not going to cost us any resources to receive the certificates, compile a list, and give the list to DCHR. I think ultimately the goal of the council might be to give this to us completely, but they can't do it without it having a fiscal impact, and they didn't have the money for it.
So one thing that I can anticipate is that now that the lawyers in the agencies have been severed from the Office of the Attorney General, this is going to be sort of like the FDS issue, which is who are the lawyers? Are they serving as lawyers, right? Because we have plenty of lawyers who don't serve as lawyers. And who's maintaining these lists and where are they going? So that, I think, is going to be kind of a, it's going to be an issue.
And I haven't, to tell you the truth, I haven't seen the actual bill that was voted on a few days ago. There may be something in there, including the change to the December 15th date, which we support, but there may also be something in there about the lawyers, only the lawyers that have to be lawyers for the district government have to file.
Based on service, so only those in the legal service? Because you can't, if you did that, then you'll lose the accepted service employees, right? Not to mention the executives. So I guess I would just be careful that you could be a lawyer and not be in the legal service. I mean, the reason I even raise this is that I had this issue figuring out who the lawyers were and what role they were serving in. And if you're in a policy position, right? If you're a DYRS and you are not in the Office of General Counsel, but you're sitting as the Director's Chief of Staff, let's say, but you're providing him or her with legal advice on a regular basis, but you don't sit in the legal service, you sit in the accepted service. Are you a lawyer for purposes of the DC government? Are you not a lawyer for purposes of the DC government? And do you have to file one of these things? And it matters, obviously, for compliance with the law, but it also matters where you're barred, right? Because there's an exception in the District of Columbia to go ahead, you can practice for the DC government for up to 180 days without being a member of the DC bar, as long as you're licensed somewhere. And so therefore, if you're hired in, and this may be an issue that presents itself sooner rather than later, if you're hired into the DC government, not a member of the DC bar, and you're put in some position that is not necessarily the Office of the General Counsel in an agency, because you're now hired not by the Office of the Attorney General, you're hired by their individual agencies. Who decides? Who reports it? And how do you, Office of Government Ethics, get word of who the lawyers are for purposes of maintaining the list and reporting who did not, in fact, file a certificate? Right. I realize the DCHR will bear ultimate responsibility for housing and then enforcing, but if you're collecting and reporting out, if you will, that strikes me as being a rather sticky wicket.
Well, here's the thing. It's DCHR that's going to be responsible. We're going to provide the list just of people who filed, not the people who were supposed to file. And so DCHR will take the list of those who actually filed with us and compare it against their list of who's supposed to file. And through their rulemaking, they need to clarify what you've just mentioned about who has to file, and then they need to take any enforcement action. But right now, we are like a drop box, and that's it. We serve no other purpose than as a drop box.
I think we should keep it that way as long as we can for those reasons. And when I read the article you sent, I thought, now here's a guy who's like, the good people are being punished for what the bad guy did. And also, I thought, like, what's a certificate of good standing? You know, in D.C., the bar now is so mechanized, you go online and see. So my certificate of good standing, the only one I could produce without a hassle would be to see if I could print out my D.C. bar, you know, she's, you know, in good standing. They don't, so as I wasn't, if we have to now, or if somebody, not us, has to create a new certificate of good standing and process a document, that's a real, like, issue for me as a citizen taxpayer and streamliner. If they can simply, like, go on the DC Bar website, you know, that's fine.
Okay, well, we'll be vigilant if there are further amendments to the bill that seek to on. We'll certainly take it up. Okay, non-confidential investigations. We don't have any to report this month.
Okay. So the time is now 12:34, and I see no members of the public here at the meeting today. Normally, this is our period for public comment before we go to an executive closed non-public session. So at this point, I will entertain a motion to move to an executive session to discuss ongoing confidential investigations pursuant to DC Code 2-575B14, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Code 2-575B13, and personnel matters pursuant to DC Code 2-575B10.
Should we shut the video and then restart it?
Well, let's just get a motion first, and then we'll...
Oh, I'm sorry.
So moved.
We have a motion, seconded. All in favor say aye.
Aye.
And no opposed, so we will go ahead and move, it's now 12:35, to a closed session. So let's go ahead and stop the video at this point, and then we'll restart it so it's got a... Okay, the time is 1:10, and we are back on the public record. We've opened the door to allow the public in, although no one is here. So I will just say very briefly that during the closed portion, the board approved, and I signed 3 negotiated dispositions, one in 1218-001 Kathleen Steins, 1213-001 Mark Poindexter, and 1228-001 Tanyel Plater, all three of which will be posted on the board's website today at some point. So any further business? So we are adjourned until next Thursday when we have our open house. For
Meet and greet.
A meet and greet, exactly.
1 o'clock.
Here, right? In
Here,
this board-
right in this room. December 11th.
All right, and then after that will be the January meeting. We will get Mr. Grimaldi comments on the best practices report by the end of next week and the other follow-up matters that we discussed. Thank you all very much for your efforts and work, making this move along very quickly.
Thank you, board.